If not, we turn to our second presenter, Harry R. Marshall, Jr. Mr. Marshall was a senior legal advisor in the Criminal Division at the Department of Justice, is an adjunct professor at the University of Virginia School of Law, and previously had a distinguished career as a principal deputy assistant secretary in the Department of State and as an arms control agency senior attorney in the SALT negotiations. Mr. Marshall will address reducing prison populations, one of many needed criminal justice reforms. Mr. Marshall.
Well, thank you, John, first for inviting me to this forum and for your very kind introduction. My paper and my remarks today address the prison overpopulation in the United States, to which John has alluded to in his opening remarks. But let me start this with a brief discussion of the nature of this problem. Fundamentally, prisons in the United States are way too overcrowded. As John mentioned, with less than 5% of the world's population, we have 25% of the global population incarcerated. Well, that's 25% of the total people who are incarcerated are in the United States. One widely cited study has concluded that this comparatively high level of incarceration does not have a substantial positive effect on crime rates. So let's think about that. And the cost of maintaining correctional facilities in the United States amounts to approximately $260 billion a year. That's federal and state. The average cost per year to incarcerate a federal prisoner is $26,000 or more a year. And this total expense consumes about 1/3 of the budget of the Department of Justice. Funds needed to maintain a prisoner in a state institution are between 2 to 3 times the amount allocated in such state to each elementary school student. In my view, meaningful efforts to reduce prison populations may best be initiated now by the creation, by executive order, of a presidentially appointed high-level bipartisan commission. Before talking about this commission, let me briefly identify a number of the issues currently posed by this overpopulation. Currently, there exists a high-level impetus and bipartisan support for dealing with this problem. Early this summer, in the wake of announcing commutations of sentences of 46 drug offenders, President Obama expressed his intention to take steps this year to revamp the criminal justice system, including sentencing guidelines, and to call on Congress to act. Of course, there's been a lot of calls on Congress without a whole lot of action. But reportedly, the Justice Department is preparing to release some 6,000 inmates beginning at the end of this month. This action is attributed to reductions in minimum sentencing guidelines for many nonviolent crimes, which can be applied retroactively. Last year, the Justice Department set criteria for incarcerated persons who might qualify for commutation of their sentences. Generally, nonviolent inmates who have served more than 10 years and would not have received as lengthy a sentence under current sentencing rules. Press reports have noted that overhauling the criminal justice system have become a bipartisan venture as candidates seeking the 2006 presidential nomination have focused on the issue, and lawmakers from both parties are collaborating on legislation. Earlier in this Congress, bills seeking enactment of the Smart Sentencing Act of 2005 introduced. According to a NGO, Families Against Mandatory Minimums, the proposed legislation would reduce 20, 15, and 2-year, and 3-year mandatory minimums to 10, 5, and 2 years, respectively. The bills would permit some 8,800 federal prisoners who are in prison for crack cocaine crimes to seek fairer sentences in line with the Fair Sentencing Act, which reduce, but only prospectively, the disparity between crack and powdered cocaine offenses. The Department of Justice estimates that such enactment would lead to saving $24 billion over 20 years and remove the need for construction of more than a dozen prisons and hiring of thousands new correctional officers. Now, the Smarter Sentencing Acts didn't get much further than being introduced as bills. There was not exactly committee leadership support, but recently, a new bill titled the Sentencing Reform and Corrections Act of 2015 was announced by and with the support of the leadership of the Senate Committee on the Judiciary on October 1st. It encompasses the essential elements of the earlier bill. And more recently, on October 8th, a similar bill was introduced by the House Judiciary Committee with the support of the chairman and the ranking member. A study by the Brennan Center for Justice in New York University School of Law states that dealing with mass incorporation is now one of the few issues on which the left and the right are coming to agree. And notably, Republicans are leading the charge, including Charles Koch, the conservative billionaire who has become an advocate of sentencing reform. In congressional testimony this past July, John Malcolm, a senior official with the Heritage Foundation and former Justice Department Assistant AG, observed that mandatory minimums ultimately swept more broadly than Congress originally intended. And he concluded that reducing mandatory minimums will not reduce the incentives of low-level drug dealers to cooperate. Malcolm noted that over 30 states have rolled back mandatory sentences, and he pointed to a recent report by the Pew Charitable Trust that over the period of 2008-2010, 10 states had cut their imprisonment rates, experienced greater drops in crime than 10 states that increased such rates. Now let me throw out a few statistics. As mentioned, with less than 5% of the world population, the United States has presently incarcerated about 25 of the persons in prison worldwide. The Brennan study concluded that this comparatively high level of incarceration does not have any substantial effect on the crime rate. Currently, 795 persons are in federal custody. And as of the end of last year, a total of 1.5 plus million persons are incarcerated in total in state and federal systems. For what it's worth, despite what some Democratic presidential candidates asserted in the last debate, there are now less persons incarcerated here than in China. Some assert that the reduction in U.S. incarceration has helped drive down crime, though there's debate as to how much. It is evident that state government's prison costs have a detrimental effect on educational funding. The Brennan Center points out the cost of maintaining correctional facilities in the United States, as I've mentioned before, amounts to approximately $260 billion annually. Funds needed on an annual basis to maintain a prisoner in state prisons are between 2 to 3 times the amount allocated to such state for each elementary school student. For example, in New York, $18,000 is allocated for such students per person versus $58,000 spent on inmates in New York State. In September, Education Secretary Duncan asked states and cities to dramatically reduce prison terms for nonviolent crimes and to use an estimated $15 billion savings to substantially raise teacher pay in high-poverty schools. Another commentator on this issue, Stephen Hawkins, cites the example of Los Angeles, where over $1 billion is spent annually to incarcerate people from communities with high crime rates. But the Los Angeles Unified School Budget was projecting a deficit of $640 million. Besides funding federal prison operation and construction, the U.S. government subsidizes state and local criminal justice costs in the amount of $3.8 billion annually. The Brennan study recommends that such spending should be provided only to states that reduce crime and prison populations. Generally, the initiative to reduce incarceration terms has been geared to drug and other nonviolent offenders. For a number of reasons, the overpopulation of violent offenders cannot be ignored. As I noted earlier this summer, the president commuted the sentence of 46 federal prisoners convicted of drug offenses. However, Fordham law professor John Pfaff maintains that the president is wrong in his approach to focus on dealing with only the incarceration of persons convicted for nonviolent acts. Professor Pfaff points out that federal inmates make up only 14% of all persons incarcerated in the United States, so the real problem here is dealing with the overpopulation in state prisons. And more than half of state prisoners are serving time for violent offenses. And since 1990, 60% of the growth in state prison populations has come from incarcerating violent offenders. So Professor Pfaff points out the realism, and also a political third rail, that governments will need to reduce the prison terms that violent offenders face if the breathtaking prison population is to be reduced. In his article, he urges President Obama to explain that extremely long sentences, even for violent offenders, are generally counterproductive by pointing to studies that show that such punishments do not really deter crime and that offenders pose less risk of recidivism as they enter their 30s and 40s. University of Pennsylvania law professor Stefanos Bibas agrees with this analysis, stating that President Obama's narrative does not fit the facts, as state prison growth, which makes up 88% of the total prison population in the U.S., has been driven mainly by violent and property crimes, not drugs. It has become increasingly apparent that long-term sentences have counterproductive effects. Professor Bibas argues that more thought needs to be given about ways to hold wrongdoers accountable while minimizing the damage done to families. Crime needs to be punished and condemned unequivocally, he points out, but to do so in ways which reinforce rather than undercut family values. He makes an interesting analogy to punishment for crimes committed in colonial America, where few guilty persons faced long-term separation from families, but were subjected to brief, although sometimes brutal, punishment. A June article in The Economist noted the ineffectiveness of detaining persons with 50-year sentence, which does not deter crime 5 times as much as a 10-year sentence, though it costs more than 5 times as much. Of course, death sentences or life imprisonment without the possibility of parole should continue to be appropriate in certain situations, such as conviction of a person in a position of trust who has engaged in espionage, which has gravely injured U.S. national security or cost the lives of U.S. persons. Let me say a few words about the United States Sentencing Commission. Most federal criminal laws not including narcotics offenses, carry only maximum sentences. The Sentencing Commission, since established in 1984, has promulgated sentencing guidelines, which I hasten to point out are not exactly easy reading for an uninformed reader. But these guidelines include minimum periods of incarceration and are to be used by the federal judiciary in imposing sentences. The guidelines and amendments thereto are adopted by the Sentencing Commission and take effect unless Congress objects. And some amendments are to take effect next month. The Sentencing Commission has identified as a priority reducing the costs of federal incarceration, which now exceeds well over $6 billion per year. As you know, the Constitution provides that the president may commute or pardon offenses. As mentioned above, he commuted sentences of 46 drug offenders this summer. Similar action could be taken with respect to a significant additional number of nonviolent offenses, such as the approximate 5,000 federal inmates currently serving long sentences relating to crack cocaine. Last year, the Department of Justice established, as I mentioned earlier, a clemency initiative intended to prioritize clemency application for inmates which meet 6 criteria. Further action should be taken to commute sentences of offenders whose convictions are related to crack cocaine to the minimum sentence for powdered cocaine. I would like to point out that in 2007, Families Against Mandatory Sentencing led an effort to have the sentencing guidelines for crack cocaine violations applied retroactively, which made 20,000 federal prisoners eligible for sentence reduction. Let me say just a few words about the DOJ pardon attorney, which reviews requests for pardons and commutations of federal convictions and makes recommendations for action by the president pursuant to his constitutional power. During the Obama administration so far, some 17,000 requests for clemency have been received. However, only 89 have been granted. The number is fewer than those granted during the McKinley administration. Obviously, the work of this office needs to be streamlined and broadened to assist in reaching a goal of significantly reducing federal prison overpopulation. Now, in addressing this problem, I believe we need to look closely at European approaches to punishment for nonviolent offenses, and in particular, how such nations have adopted alternatives to incarceration. For example, Germany and the Netherlands incarcerate persons at about 1/10 of the rate in the United States, and under conditions geared towards social reintegration. American and European civil law penal systems differ in every imaginable way. German approaches are rooted in belief that public safety is ensured not simply by imprisonment, but by successfully reintegrating prisoners into society. Non-serious offenses carry penalties for fines, probation, and community service. And where incarceration is imposed, a very high percentage of sentences are 12 months or less. Some states, such as Colorado, Georgia, and Pennsylvania, have begun to apply some European practices, such as expanding prosecutorial discretion to divert offenders, including some high-risk persons charged with more serious offenses, and using community-based sanctions rather than incarceration. The Brennan study recommends that criminal laws actually be changed to remove incarceration as an option for most low-level, non-serious offenses, except in extraordinary circumstances. Another recommendation is to mandate effective treatment of persons with mental health and addiction issues, as 1/2 of persons incarcerated in the United States suffer from these issues. I want to wind up this afternoon by addressing the proposed presidential commission I mentioned at the beginning of my remarks. In the Brennan study, a chapter by former Senator James Webb concluded that now is the time to revive the push for a national commission to address the overall issue of mass incarceration. Senator Webb had initiated such an effort with legislation in 2009, which was not enacted. And his article identifies many of the issues related to mass incarceration and spells out how such a commission should be organized. Given the many entities which must be involved in a successful effort to effectively reduce the size of U.S. prison populations, the creation of such a high-level and well-funded commission is an important step in bringing about solutions to the problem, much like President Johnson successfully did in 1967 when dealing with urban riots which have swept many parts of the United States. My recommendation is that the President establish by executive order a well-funded bipartisan commission with a mandate to take all appropriate actions to, 1, establish priorities for the commutation and other reduction of imposed sentences for federal offenses, and to streamline the process for executing such determinations on a fast-track basis. 2, recommend to the Sentencing Commission that accelerate further efforts to adopt lower minimum sentencing guidelines for nonviolent offenses. 3, encourage prompt enactment by Congress of legislation further reducing statutory mandatory minimums for narcotic offenses and other nonviolent crimes. 4, study and take into account how European nations have managed prison terms, resulting in a significantly smaller prison population, and following European models, develop proposals to significantly reduce sentencing, except in the most serious of cases, for narcotics and other nonviolent crimes, and to utilize alternative non-custodial sanctions. 5, recommend that federal criminal justice funding for states be increased, but restricted to only those states which achieve significant reductions in numbers of incarcerated persons, and which remove onerous and unnecessary constraints on job hiring of former inmates and child support obligations while incarcerated. 6, recommend increased spending for training of inmates and treatment for drug abuse and mental impairments. And 7, include officials from state authorities in deliberations of the commission with a view to encouraging similar action on the part of state governments. On this topic, clearly much is being uttered by commentators and political leaders in the United States, from which can be drawn at least one conclusion. The prison population at federal and state levels are way too large, resulting in the consumption of substantial government funds which could be used for other important programs and not serving any useful purpose with respect to a number of prisoners serving long terms for nonviolent and possibly some violent crimes. Addressing this problem will take much more than rhetoric, but White House prioritization and high-level efforts such as the establishment of a presidential commission to further analyze the existing situation and take concrete action based on such analysis to reduce the populations through 2 basic approaches. 1, releasing by means of commutation persons now incarcerated who are deemed not to constitute any reasonable threats to public safety. And 2, reducing a number of persons sentenced to incarceration with long sentences for nonviolent and possibly some violent acts. I would ask each candidate seeking his or her party's nomination as follows. If elected, will you, during your transition, devote sufficient resources to establish the parameters for an appropriate commission to address effectively the means by which prison overpopulation can be rectified, so that members of such a commission and staff can be appointed and begin substantive work within the first 100 days of your administration? Thank you.
very much, Mr. Marshall. Are there questions for Mr. Marshall? Would you please come to the microphone to ask your question?
My questions concern, first of all, the correlation between crime and sentencing. I would be interested if you could in a nutshell, summarize what do you think that relationship is? Are you suggesting that there is not really a causal relationship between the commission of crime and the sentencing guidelines and punishments that are currently in practice?
Well, to some extent, that seems not realistic. Just because you reduce sentencing, are you going to reduce the crime rate? But apparently, there may be other reasons involved. That has occurred, as I've mentioned, in a number of states, and according to an extensive study done by the Brennan Center at NYU. So I think there is a correlation, and for a number of reasons, besides the reduction of crime rates, the reduction in long sentences can have a beneficial effect.
So would you say the Brennan Center is, there's a consensus on this amongst students of criminology? Is there any consensus in either of the parties? What has led people, why do people now conclude that what they did before, as in 10 or 15 years ago or 20 or 30 years ago, that leads them to now believe that there's less correlation between crime and sentencing than they thought before?
Well, I think a lot of this is based on the fact that now, decades later, the efforts, at the federal level with the 1980 crime bill basically was swept more people into prison than was anticipated. And I think the realization that these long prison terms are counterproductive. So you're keeping people off the streets, but you have, after a much shorter period of time, have effected punishment. And even though there is this high degree of recidivism, that keeping people in prison for less time is going to reduce recidivism rates, because persons are going to be able to better adjust to society on the outside.
Thank you.
I must say I was shocked to hear in your very excellent presentation that there are more Americans in prison than Chinese. And at first I thought you must mean per capita, and I used my iPhone and Google to do some quick figuring, and it appears there are roughly 5 times more prisoners per capita in America than there are in China. Have you actually correlated that with the difference in population between the two countries? I only got one bar.
No,
You're actually
when I
saying there are
checked,
more total number of prisoners.
there are 1.6 million people incarcerated in China, which is slightly more than the 1.5 million incarcerated in the United States.
What I came up with was in China between 119 and 165 per 100,000. So you'd have to do the math. And I honestly don't know the population of China, but I was guessing it was between 1.5 and 2 billion. But I may be way off on that. But at any rate, it's an excellent talk and really very enlightening. Thank you.
Yeah, well, the United States still is way ahead in terms of percentage of the total
Well, certainly,
populations.
yes, by a factor of 5.
Mr. Marshall, thank you very much. Clearly, we have a problem of over-incarceration at both a federal and a state level that needs to be addressed as a very serious national problem. As we do that, however, we don't want to go to another extreme and create more problems than we already have. Can you talk a little bit about doing this the right way? I gather that Proposition 47 in California, poorly drafted, has led to some problems in relation to repeat offenders of nonviolent offenders feeling this is kind of a get-out-of-jail-free card. And obviously, we want to do this well, we want to do it with careful study, but it's an essential national need that we address this.
Well, California is one of the states that's taken action to try to deal with prison overpopulation. You may recall that a few years ago, there was a federal court decision that said, California, you just got to let something like 20,000 people out of jail, period, because your jails are way too overpopulated. But so this Proposition 47 was an initiative on the ballot several years ago that basically said for certain low-level crimes, there's to be no incarceration. For example, one of the crimes was theft or shoplifting of less than $950 property value. But what's happened is you get repeat offenders who are, there was one example of someone who was arrested shoplifting, had a calculator with him that was making sure he wasn't stealing items that had a value of more than $950. I mean, obviously what they should have had was a provision in there that something like, okay, you do this more than 2 or 3 times, you know, you're going to have to be subjected to some kind of incarceration. So I think it was a poorly worded initiative, and it led to this get out of jail free situation.